Is the ethics fear keeping you from leveraging AI? It's justified, just not for the reason you think. Here's everything you need to know about ethics and policy in AI for family lawyers. Welcome back to the Sterling Family Law Show, the show for family law firm owners who want to grow their profits, multiply their cases, and set a clear roadmap on what they need to do to build the firm of their dreams. Our episodes break down proven business growth, digital marketing, and revenue-first strategies to help you scale smarter and not just be busier. I am your host, Tyler Dolph. I'm also the CEO of our hyper-focused digital marketing consultancy called Rocket Clicks that was born out of our very own family law firm, Sterling Lawyers. And today we are talking AI. I have Tony Carls, who is the co-founder of Sterling Lawyers, with us, and we are going deep. Today's episode, we outline the false belief that AI is not safe for family lawyers and why safety is a tier issue, not a tool issue. We're going to talk about the formal ABA opinion on AI, and then we're going to talk about building your own AI policy, something that every firm who wants to use AI needs in place. Tony, welcome back. We're getting deep into the weeds with AI and family law firms. Today, I want to start on the false belief that I feel like some family attorneys have, which is that AI is not safe for law firms. And I think maybe done incorrectly, that's correct. It's totally not safe. But there is a way to leverage AI for your family law firm. Talk us through the difference between enterprise, accounts and AI versus like your run-of-the-mill chatbot that people download on their phones.
Yeah, so most of these platforms, so Claude, OpenAI, XAI with Grok, and then Gemini, they all have essentially, there's two streams of interaction that you can have with them. One would be what's called a consumer grade account. And those are all, you can get them in a couple different variants, but typically you can get all of them for free. So you can go sign up right now, just put an email in, and then you get access to use the LLM. You can chat with it, you can do certain things with it. But it's not free. Free means you're the product. So just know that. And if you're a lawyer and you're the product, that means your data is the product, and you can't be sharing that information with these companies, because they're going to use, these are going to be, the data is going to be used to train their models. And if you're putting client data in, that's now part of the public repository, and you have actually violated ethics rules. So there's that vein, and it doesn't matter if you're in a consumer grade product and it's free, or you're doing like a plus version where you get a little extra utilization, or you're doing a max version where you're getting the whole kit and caboodle. It's still a consumer grade terms of service, and like, you got to read through it. They're going to say that you have some control over whether it turns on or off and certain things like that. But the reality is like, it is a different terms of service. It's a different contract. It's a different workflow. And it is piped for leveraging your data to do data model training. And even the paid versions, I would say, are risky to use, and you should be entering a contractual relationship with them in what would be called an enterprise terms of service. And again, on that side, there's multiple different versions of that. What I'm really talking about is how you're interacting with them from a terms perspective. When you enter a business contract, that data is then contractually obligated not to be used for creating more or used for training. You have more controls. There's more features from a business perspective so that you can do it. Typically, they come in a couple of basic genres. You have the Teams, which is kind of your entry level account. Same contract, but lesser tools. You have an enterprise version, which is going to have a whole bunch more tooling, but it's the same contract as the team account. And then you have what's called a platform account, which is really your API. If you're building applications, directly to these LLMs, and you need to plug the application into the AI for it to then interact. That would be another way to do it. That's also under the same enterprise terms of service that you're typically using. So I'm speaking specifically from the concept of Anthropic. That's been our tooling of choice, and we have ensured everybody's moved over. We've put some AI policies in place. We've put some governance in place so that we're much more compliant with some of the opinions that have come out in recent history.
So in order to do that, for the person who's listening to this, like, oh my God, I have to get on Claude Enterprise. How does one do that?
Yeah, just go. I mean, if you could probably just put it in your chat bot or Google it, and you could say Claude Teams account. And you're going to get a landing page. You can sign up. You can directly sign up for there. You don't need to work with a salesperson in one of their orgs. If you want an enterprise account, then you probably will be having a conversation with them because there's some things that you want to define together. And then if you want API back and forth because you're building custom applications, that you can also sign up just online and enter an agreement that way. So it's very easy to do. A lot of people are opting to not do it or to avoid it altogether because they don't necessarily know what to do. But if you're using a free account, if you're not using a commercial grade account, you're likely putting yourself in a position where there's some risk.
And I think the silent kind of killer here is that even if you do that and your team or your attorneys or their paralegals are using their free account on their phone or on their computer, you're still in trouble. So you have to make sure that not only do you sign up for a Teams account, but your entire team is only using that account, correct?
Yeah, you're going to want to make sure you set that up, and B, you need to have some sort of AI policy document in place, and then a governance process in place so that you are proactively compliant. Otherwise, the reality is, if you own a law firm, the liability rolls to you; it doesn't roll to your team member. So there's some protections that you can have as the owner if you are doing the things that put you in the best position to make it a non-compliant decision that someone has made. Nobody expects every single thing that's done within a law firm to be visibly seen exactly by the law firm owner. But if there's no governance involved, then it's just, you're kind of lackadaisically maybe putting a policy together. We all know that we all have, employment agreements that are reviewed one time. We all have annual, like our team member handbooks. Those are typically reviewed one time. Now, in those instances, there's not a lot changing. In the world of AI, there's a lot changing. The utility's changing significantly. It's getting more advanced, and if you don't have a process for governance, you're kind of just being negligent there, and you're putting yourself at risk for not having a process for, like, how are you reviewing how it's being used on an ongoing basis, and is your team staying compliant, and at least doing something to make sure everybody's in using it the right way and leveraging it with the right tools, and has very clear direction from you in terms of expectations on how it should and could be leveraged. Otherwise, you're just allowing the team member to fill the gap with whatever their preference, which is not necessarily good business sense.
That's right. Well, and I think what's interesting is the ABA has not issued anything since July of 2024, their formal opinion 512, which is the first national guidance on generative AI. Can you walk us through this a little bit?
Sure. I think it's done because of how it was written. Is more general architecture of how you should think about it, because obviously it has nothing to do with any given state. It's just an overall guidance opinion. So, and then different states have adopted different portions as they've written their own. So it's basically, if you're in a state that doesn't have specific guidance, this is a good place to start. If you are in a state that has guidance, I would leverage this and as a secondary add-on to whatever the the state's guidance has been specifically.
So refer to your state as the recommendation.
Yeah, that's your, if there is one, use that one. A lot of them have been coming out with different opinions. Some have just been adding to the ABA guidance. Some have been completely rewriting it and kind of putting their whole stamp of approval on everything. So it really depends. You have to do your own research on this, but their guidance hasn't been updated because it's a framework of how to think about this, and it's which is important because that's really what this is. This is a tool. It would be like any other tool that you use in your business. It's just a different type of tool that comes with the ability to do a lot more advanced things rather than when I do X, Y happens. This is when I ask for X, a million different things could potentially happen depending on how you've programmed what you want the LLM to do in between. So a little bit different.
Yeah, I think our narrative to our attorneys is AI never replaces their judgment, right? The attorney directs the work and they can leverage a tool to support it. But for anything specific to your situation, you got to rely on the attorneys that you have and their judgment.
Yeah, I was literally just in a training today about how to use it to draft a draft MSA. So we were building a skill as a team, and the whole point of it is to like, how do we streamline process so that we can get into more of the strategic work versus just hunting and pecking for here's what goes here from this document, so on and so forth. You're still going to need to audit it, but it speeds the process up significantly, and it gets you to the strategic case work faster, and it elevates your team in a significant way. So that's kind of how we think about using it. It's not a replacement at all. It's a tool to kind of get to the meaningful work as quickly as possible, so that can then be done with a higher degree of capability and with a more thorough process. Like our biggest use case probably is how we use it for actual trial prep. So like when we're going into a hearing that's going to be a back and forth hearing, we will set up our attorneys set up projects within Claude, and then they will create a lot of question sets and then evaluate all of those. And it does a really good job looking at the whole case data and then coming up with a lot of different unique angles. Now, most of it you're gonna have to, like we've been saying, comb through it, but it allows you to kind of repeat that process really fast and get way better prepared for a trial than if you're doing it all manually. Because it's going to generate different angles and different potential ideas and all of these things at a speed at which is it's impossible for a human to keep up with it. But it's not going to be 100% accurate. It's not going to get everything right, but it's going to spur that creativity more and more. And then you get your first set back. Maybe you're looking for 100 questions. You're going to get 300 or so from AI. You're going to sift through it. You're going to re-put back in the best 100 that you want, and then you can prompt it to give you more angles on this particular topic and that particular topic, so that you can really have a thorough vetting of what you want to come into and what are all the questions that you might want to pose as you're litigating. So our team has found it super helpful for that, and it's been fun watching them embrace it and like leverage it for its actual intent, because it's very powerful. It's a super powerful tool, but it needs a driver. And if you learn how to drive the tool, it can do awesome work for you. But you still need to do the end result. If you get lazy, you're gonna get yourself in trouble.
So good. So Tony, talk to us a little bit about the the governance policy that you put in place or help put in place at Sterling? Because I think a lot of people are listening to this and they're like, okay, I got to get on a corporate account, which you have to do, and then I have to put a policy in place so that my attorneys can leverage it. How did you go about building that, and what did the kind of final product look like?
Sure. So at Sterling, we first started from a research process. So Illinois has a really strong opinion on how AI should be utilized. So that's kind of how we've based. That's where we started. We used the ABA guidance as well, but we built out a policy, and basically what that spelled out is two types of accounts. Here's the ones that are approved to use. Here's what we've selected to use, and this is where you should be operating. So kind of put everybody on the team. If you're going to be using AI, here's where you're going to be using it. It kind of went through a whole bunch of different, here's how we're going to use it. Here's how data is going to be used. Here's how it needs to fit into our client agreements. If a client opts out of wanting AI to be used on their case, that needs to be really clear. And like, obviously then you're agreeing that you're not going to use it for that file. So there's a whole bunch of different things like that we are then having the attorney sign as a agreement with us at the firm. And then we're constantly reviewing that. So we have an ongoing process of meeting with our teams and understanding kind of how they're using it, what they're using, so that we are, essentially auditing their use cases and ensuring how it should be used is compliant with how the opinions have been written, just to keep our team safe and keep them honest. So all of their accounts are accessible to us on the team, so we can go in and do these audits. And that's just something that we've taken on as kind of like an ongoing process. So it'll be something we continue to do. The benefit, obviously, is we feel like we're putting ourselves in a position where I can't see it happening, but it could happen, where someone internally gets lazy and decides that they're not going to really do the job the way they're supposed to. It puts us in a position where that's really going to hit them. Obviously, it'll be a bad black eye for the firm, but it'll be, our firm owner's license will be much more defensively positioned than if we aren't doing any of this. So a lot of what we built from a process perspective was reviewed and confirmed with our two executive partners, our two top attorneys, one from Wisconsin and one from Illinois, in terms of like how we wrote it up and how we interact with it. And then those two are the ones that are kind of leading the lawyer groups as we're doing working group sessions on implementation of different tools and skill builds and whatnot.
Love it. Perfect.
So very simply, it's policy document. It's an ongoing process for observation and adherence. And right now I would say it's pretty manual, but it's definitely worth it because we've seen really, really cool production enhancements for our team that wouldn't be available through any other means.
AI is here to help your firm. You just need to do it the right way. That's the second permit, policy. Once you've got the account tier, you know the specific rules as it relates to your state, and an internal firm policy on AI, you are clear to make the next big decision. Which AI platform should your firm actually build on? That's exactly what we're covering next week, so make sure to tune in. We're going to walk you through how to choose the right platform that works for you and how to make sure you're building on the right foundation and not just the flashiest demo. Make sure to follow the show so next week's episode lands right in your feed. We will see you there.